Showing video.
I see we have a few of you on already, so just letting you know that we will be getting started here very soon, giving a few more people time to log in, and we'll get started here in a couple of minutes. In the meantime, you see the chat feature on the right, so any specific issues or questions that you wanted to make sure were addressed by Leanne during this webinar, go ahead and start sending them in on the chat feature or the question feature later. So while we're waiting a couple of minutes here, I'm going to do a technical run through and just make sure everybody can hear me okay. And Leanne, you want to go ahead and let's just do a testing 1, 2, 3 for you?
Yeah, testing 1, 2, 3.
And so if I can get a few thumbs up here, everybody let me know that you can hear us okay, that would be great. Great, thanks guys.
Awesome.
So while we're waiting on a few more folks here, let's do something for fun here. So Leanne's last name, if everybody can see it, actually, Sammy, can you go ahead and let's put up Leanne's last name? I think it's on the next slide, right? We'll have a little fun with this. All right, so that's Leanne right there, and Gisela was me, the first slide. So I'd like to hear what everybody's interpretation is of that last name. If anybody wants to take a shot at how you pronounce it, Leanne has a cute way that she taught me on how to pronounce her last name. So if anybody wants to give it a shot, actually you could do it phonetically in the chat if you want, or you can audio it, whichever one you want to use.
Phonetically will work in the end.
Yeah.
I was going to say, try that.
I don't think anybody's even going to take a stab at it.
I know, it's one of those things. It's one of those things. Should I put them out of their misery or?
Do you guys want to guess the origin of it? We can start there.
Yeah, there's 2 ways that one could go, actually. So.
Yeah, I agree. So you can go ahead, give them the origin. That's a good clue.
Yeah, so it's actually Italian.
That didn't help anybody.
It didn't help anybody.
Let's give them a second before we start giving what it is.
Champagne, Gravagne. Okay, I get that a lot.
Close.
I get that a lot. It isn't that, but that was much better than Gravagne. Although I should not have given that away either, because maybe somebody would have guessed that. So no, it's actually, if it's Italian, you can rhyme it with lasagna. So Gravagne. That's the easy way to go about it. Would anybody have guessed that?
No, but Julie, that was a pretty good guess. So I'm putting you on the list for Starbucks gift card, because that was a pretty good one, actually. I had no idea how to do it.
Yeah,
so.
Thanks for playing.
I think we can get started a few minutes into the half hour, and we're going to be very good on time here and try and stick with our time schedule of 30 minutes. So now that we all know how it's pronounced, it's Leanne Gravagne, like lasagna. She's an attorney specializing in employment law. And Leanne started her career in human resources in 2006. And at that time, she recognized that there was this growing need for employment issues to be addressed by counsel. And so she went off and put herself through law school. And now she lives in Southern California with her husband and her beautiful 2-year-old daughter.
Yep.
And so she's given us some time here to help all of us understand a little bit of, and we call it pitfalls because it's like a nightmare to deal with the new employment laws, and we're going to focus a little bit on just for this year. But so with having said that, let's go ahead and have Leanne get started, and we will be moderating your questions as we go along. I'll try and address them as we go. If we are, getting behind on time, I may leave them all for the end so that we can be very respectful of your time commitment today. So, okay, go ahead, Leanne. Let's get started.
Great. Okay, I'll try to navigate this this PowerPoint here. Here we go. Okay, so this is obviously the Cliffs Notes version. A lot happened in 2017 in the employment law realm, but that's not new. It's every year. So some of this stuff was a continuation of things that have already been going on. If you're located in the city of LA, you already are familiar with some of these things. So I'll start out here with a fun questionnaire and a little poll. And the question is, when does employment liability begin? And we've got a few options here. A, at the time of hire. B, when the candidate applies for a position. And C, after 90 days of employment. And I'll give people maybe a few minutes if they want to go into that poll and play along a bit. You know, I think a lot of people would be inclined to choose a few of these answers, and they wouldn't necessarily be wrong for guessing so, but haha. Here we go. We've got some people ringing in. Okay, we've got somebody for at the time of hire and when the candidate applies. So it looks like those are the two most popular, and that would be pretty accurate. So I think we can eliminate C if anybody else wants to go for one more guess, and then we'll give it away. And we'll hit through this slide here.
And we'll leave the poll open as well, so you can go ahead and
Continue
add your poll
through.
answers, and we'll go back to it at the end and see kind of where we ended up with those answers.
So the answer is actually when the candidate applies for a position, and this point is probably arguable if you're a plaintiff's attorney looking for work. So, you know, obviously when they apply, we all know that what you've posted in your job description and who the person is can inform whether or not you have some exposure. And interestingly enough, I have had a client post on LinkedIn at a certain point that they were seeking young associates for a growing company, ! And obviously that would be problematic on its face and could open you up maybe questionably prior to an older person over the age of 40, that's the standard, submitting their information to be considered for employment. So that's just a fun or not so fun consideration. All right, so we'll jump into hiring. Hiring changed a lot in 2018. Some people have been dealing with a few of these kinds of regulations for years, but California is for the first time ever late to the game on this. They've decided that you can no longer request salary history information. So that means if you have applications or interview questionnaires that request that information, let all of your hiring managers know. You now know, do not ask it. You are not allowed to consider that any longer. And, you know, there is some workaround for this. You can ask an applicant what their salary requirement is, keeping in mind, of course, that the common response to that question is still, for some reason, what the person is currently making. So if you learn that information, even though you didn't ask for it, please note that you still cannot consider it. And then it's important to look at why this is a rule. Obviously, pay equality is a big issue. It's a hot topic. And, you know, this is sort of furthering the effort, you know, through the state of California on making sure that gender pay is equal. We'll see if that pans out. All right, and then as far as your job applications are considered, we have also banned the box. Some people have probably heard that phrase, maybe if you haven't. It means that you can no longer ask about criminal history questions. So I would completely avoid that at this point. It used to be that you could ask things with some variation, but now just eliminate it entirely. Where does that leave us as far as, I'll get you to the next slide so you can see. So now you can actually offer a position that is conditioned upon a successful background check, but you have to be careful because there are, of course, rules involved in doing this as well. If you should get a background check back that has some kind of negative or adverse information on it, you will want to consider it in multiple ways. And you should include considerations of the date of the offense, surrounding circumstances, and the relevance of the offense for your job. And if you decide that you are not going to continue to extend an offer based on the information you get, you are now required to give written notice to that person when you've made that determination. And then they are given 5 days to reply to that before you can make a final decision not to move forward with their hire. This is a very complicated area, so I would recommend that if this comes up in your practice, in your company, that you contact your employment counsel immediately and have them navigate it with you to avoid any discrimination issues that can crop up in this area. And again, if you've been in LA, this is not something new. This is something that went into effect last year that you've had to navigate already, or hopefully have had considered prior to January 1. So we can move forward. So now this is Giselle's favorite area. So third-party conduct is always a unique situation. People ask, are they liable for the acts of third parties coming into their job place as it pertains to their employees? And the answer is yes, you are liable. You do need to consider who you have coming in and out of your publicly accessible areas. So, the traditional example of this has been harassment. For several years now, we've known that if you have the FedEx delivery guy coming in and he is improperly propositioning your secretary, that you could end up liable if you do not act on that. Now it appears that it's even a little more extended than that. In 2018, we have a new case where we had a situation where a hotel was aware of a guest who was being a little rowdy with the staff and unfortunately propositioned a few housekeepers and ended up raping a housekeeper. The bottom line there was the hotel was liable. So this is a scary area, and I would definitely recommend that you look into any coverage that you currently have and check that you're covered for acts of third parties. And I don't know if Gisela wants to speak to that point at all.
Well, I do have a question that gets raised by a lot of our healthcare clients, which is what exactly is considered sexual harassment? Because they start to hear, well, if there's a text that somebody sends, if there's an explicit cartoon up by the copier, can you expand a little into when, because that seems to be the hot question we get a lot, particularly you have hospital-based physicians, so there's a lot of interaction with third party for them. And most of our healthcare clients are going into facilities with some frequency, so it's a greater risk on third party than it is for their own employees. So if you could talk on that a little bit for a moment, that would be great.
Well, first I'll start with the standard, which is knew or should have known. That's a negligent standard. So if you were on notice, or if one of your managers was aware of, even vaguely, anything that's on the line of harassment, sexual harassment, then you are at that point going to be considered responsible if you don't take the appropriate action. And what is considered sexual harassment is a fact-intensive inquiry. So it's kind of a case-by-case thing. And unfortunately, you don't get very good answers in this area. But generally speaking, it's pervasive conduct. So it wouldn't necessarily be an offhand one-time comment. That would not necessarily give way to what we would consider sexual harassment. However, repeated emails or, repeated conduct that you're aware of that goes without an investigation, that is going to rise to the level most likely where you'd be liable. And you would not, you would have needed to separate the parties, conduct an investigation, and determine if there's any validity to the claims of the person. And remember, the person does not have to come to you and say, I feel I am being sexually harassed. That's not a requirement. So if you're aware of it, you may need to step in and take action regardless of a complaint being made to you. So.
Okay, that's news to me. I thought there had to be a formal request by the harassed.
No. If I walk by my secretary every morning and I start to see some third party, delivery person doing something and they just feel they're very uncomfortable, they can come back later and say, well, you saw, you knew, and you just didn't do anything. And that has happened, and that has been a problem for employers.
Yeah, makes sense. Okay.
Great slide. This is an exciting area for California. We're a little behind Colorado, but not by much. So marijuana is now legal, and there are implications, I think, that Gisela likes to talk about, and there's also employment law implications. And actually, for once, they are that no news. There really is no significant change just based on the legalization of marijuana. So if you want to read this fun language, employers do not have to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace. So you are still permitted to make sure that your workplace is free and clear of mind-altering substances. So you are going to treat marijuana essentially the same way you would treat alcohol use and narcotic abuse. It is essentially the same thing. However, we recognize that testing for marijuana does yield some problems when you're making considerations. And so if you do have a situation that crops up in which you feel drug testing is appropriate, that of course has its own set of rules, and you do get a positive marijuana result, you're going to want to reach out to employment counsel to discuss all of the facts and, going forward, what determinations you make. Because unfortunately, there are some discrimination on the basis of disability issues that can come with this area of the law. And so, unfortunately, it isn't as straightforward as I would like. However, ultimately, there is no real change in the practices that have always been sanctioned by the state of California.
Yeah, and I think, Leanne, what most of my clients are telling me they're doing is at least trying to educate their workforce on what is their policy.
Mm-hmm.
Do we test? Do we not? Are we okay with you being stoned at your desk or not? At least trying to give them
Right.
some idea.
Guidance.
Yeah,
Mm-hmm.
so that seems to be, what I'm hearing from most of my clients is that they're at least trying to put some policy together that says,
Right.
and I'm sure that's something you can help
Absolutely.
put in place, but that's what I'm hearing from most people.
Right, and you want to be sure that your policy is is a compliant policy. So it is difficult. There are some things to navigate when it comes to drug testing. So you want to make sure that you're making at least a few considerations. And I won't get too into detail here because I want people to stay awake. But, you do want to make sure that you're dealing with safety sensitive positions or reasonable suspicion that somebody is under the influence on the job before you call off and order a drug test. And this is a post-employment drug testing only that I'm talking about, not pre-employment drug testing. Randomized drug testing is really not something that you're going to be able to easily get away with unless you can call the position safety sensitive. So if you do want to make a determination on what positions in your office are safety sensitive, I would also recommend discussing that with somebody or reading up on those regulations, because at the end of the day, it will boil down to the individual's right to privacy as construed by the California Constitution versus the employer's interest in whatever that drug test is going to yield. So it is a balancing test. It is not necessarily straightforward.
All right, and we will have actually a more detailed webinar on medical marijuana later in the year, and so we'll send out more information on that, but I wanted to at least touch on it here today because we've been hearing a lot about prescription painkillers and the problem we have as a country with that, and so many people are turning to medical marijuana. So it'll heat up, I think, this topic over the course of the year. All right, let's go. Speaking of medical marijuana and breaks.
Break time. What can they do on their breaks? I mean, technically anything they want, I guess, if you don't want to be on the wrong side of the regulation there. But the reason I bring this up is actually because in the healthcare space, this is an interesting thing if you've got employees on 12-hour shifts. And there is now, again, some question about whether or not you can have second meal period waivers for a 12-hour shift. So we know that we can get under 6 hours, we can get a first meal period waiver. And beyond that, people need to have a meal period before the start of the 6th hour. So if they work 6 hours and 1 minute, you're kind of in trouble there if they haven't taken a break. The 12-hour waiver comes into play for shifts over 10 hours. Now, it used to be that anything 12 hours and 1 minute, you were not permitted to get a second meal period waiver. However, in the last several years, that has been called into question for healthcare employees specifically. This is hospitals, urgent cares. The list goes on for that. If you want to know if you fall into that category, I would suggest you reach out to counsel to figure that out. And now we are awaiting a decision from the California Supreme Court after a few different interpretations of the rule. So it looks like anything over 12-hour and 1 minute, we will be okay to have people waive a second meal period. But California may come in and change that. So we're going to watch that closely. And I would suggest if you've got, staff doing 12-hour shifts that you are careful and you talk to counsel about the best way to navigate it to make it all work for your business. Because in these gray areas, sometimes you just make the best decision for the time, knowing you could end up, having to change your policy if it changes with the legislature or with the court system.
So Leanne, a question I get on that sometimes is, how long does a meal period have to be? And can they just eat at their desk?
Yeah, that's a good one. So after we had the decision in Brinker several years ago now, the standard is a little bit relaxed, but I would not get too comfortable. So you just have to make sure that you are providing uninterrupted mealtime. And a lot of employees do tend to want to stay at their desk and do personal things. And, I would just caution you that if they are continuing to do work and they say that they would just prefer to do that, that maybe you go above and beyond to document that you've provided them with the time and that they are elected to do this so that you can at least have something to show in the event that they decide later after, a party with the plaintiff's attorney that maybe they can get some, extra income off of all their quote missed breaks that they elected not to take. So I would be careful of allowing that, but I recognize that practically speaking, some, you may make some exceptions there. Just document. All right, so there's always annual considerations, and I'll just jump into a few of those to remind people that perhaps they need to review their minimum wage. Depending on where you're located, the answer can be different, so I will not get into specifics. However, keep in mind if you're in California that there is a new minimum wage for 2018. In the city of LA, they have elected to be on a different schedule and are expediting us to the $15 an hour standard that seems to be popular now. Also, if you're outside of California, on that off chance, keep in mind to look at the federal minimum wage. It's not changing at this point, but you always want to check because those are the things that sneak up on you, and then you have a wage claim that you just didn't expect and you would have corrected could you have helped it. The other thing to consider is that there are new I-9 forms. Make sure that you are using the correct I-9 form at the time of hire. That's a pretty simple Google search. I wouldn't go chasing down counsel and paying a billable for that. But if you are concerned if you have the right one, then definitely check with somebody. All right. And then we'll get down to the point, which is risk, I guess. All of this stuff leads us to what kind of risk are we dealing with? A lot of what we talked about today is wage and hour risk and a little bit of the discrimination implications that you can get into from an employment standpoint. And of course, you are on the hook for all of that. There are policies that can cover this. And, I'm a big proponent of EPLI insurance. The first question I ask new clients is, what is your EPLI policy? And I need to review it. So, there are some considerations with EPLI, and I know Gisela is very good at, navigating that portion. That's not my area specifically, but you definitely want to look for third-party coverage, especially based on what we just talked about. It seems that the standard is getting worse for the employer, not better, which is typically the case. Also, something I get commonly with clients is that the retentions are high for these policies. The reason for that is because the claims are very expensive. And very commonly, statutes provide that the plaintiff, your former employee, can get attorney's fees. And you can imagine if you see it through all the way, an actual trial, that those sums can become very high and actually on average, are in excess of $250,000, sometimes quite a bit more if it's a class action level suit. There are a lot of considerations there. So you definitely want to have some kind of peace of mind and coverage on these things.
Leanne, are most of the plaintiffs' counsel taking these sort of cases on contingency, or what are you seeing out there?
Absolutely. These are big money makers for plaintiffs' counsel, and so they have no problem, even if it's just a meal and rest period case. They can collect claims by looking at pay stubs, for example. They'll look at it and find one technicality and add that to their claim. And they can make enough money that they're comfortable taking this on contingency. So no, employees do not have to come out of pocket for the most part, especially if they've got a couple of good facts behind them. All right. And then I guess we can take it to any questions.
Yep, we've got 5 minutes. Thanks for staying on track with time, Leanne. I appreciate it.
Try not to get too specific. There's a lot to unpack.
All right, let's take a look at some questions here.
No, we did have another vote, so we did have another person for B, so they were right. That's good. But couldn't click on it.
So Leanne, one of the questions that I hear with some frequency is, and we talked about it a little bit before the broadcast here, is the 1099 versus W-2.
Mm-hmm.
In healthcare, we see that a lot. We do have a lot of groups that end up wanting the 1099 because there tends to be more flexibility in scheduling, particularly when you get into ER or hospital-based physicians.
Absolutely.
Can you talk about that a little bit?
Yes, I can. So misclassification issues are pretty big right now. There's been a big uptick in regulation on misclassification of workers. One thing that I would caution people against, and that I see in the healthcare space quite a bit, is this idea that because the industry has been in the past to have a lot of contractors, that therefore in the future this should be fine. There are a lot of rules in this area. There are federal rules, there are state rules. There are IRS interpretations of this rule, as well as California Employment Development Department interpretations of this. And not all of them agree with each other. In fact, I think none of them really agree with each other. And so you really do want to look at, when you're classifying someone, the test that applies to you and make the best decision based on the realities of the job that's being done. Things like they are free to choose their schedule can be helpful to a 1099 determination, but they're not determinative. There are other factors. So you want to look at many things when you make these classifications, and then know, if you've classified an entire workforce as 1099, that's going to definitely draw some attention. It doesn't mean you're wrong, but it will draw attention. And all it takes really, as we were talking about a little bit earlier, is one person to go and apply for unemployment these days, not understanding the nuances here, and say, yeah, I want unemployment. And now you're on the Employment Development Department's radar. They have beefed up somehow with all this money that the government doesn't have. They've beefed up their ability to go and audit people, and they are assessing back taxes and penalties. And it's happening a lot. So definitely.
So let's talk a little bit about that. And actually, Julie's just sent in a question, if we can address that real quick. She says, has anything changed yet? Can the W-4 be electronic signature by the employee?
Yeah, that's a good question, actually. My understanding is that the W-4s can be an electronic signature. In fact, you will find a lot of payroll providers have done a lot of these onboarding documents in an electronic fashion. The I-9 is actually permitted to be in electronic form now. So specifically, I haven't looked at that recently, but my understanding is that yes, you can. And I would say let's look into it a little further, but I'm pretty sure that you can do most things electronically now, including the W-4.
Okay, and I've also had the question from several clients as well when it comes to stuff. We started getting a little into HIPAA, and we won't get into a full HIPAA here today because that's a whole nother webinar. But I do get questions on that front when they start getting electronic signatures on I-9s, or even their payroll providers are all in the cloud now, it seems. So one of the questions we get is, well, how liable I am for my employees' information if my payroll provider is storing all of it. So I get that question a little bit of like, well, I'm running all my payroll through this in the cloud service, whether it's ADP or whoever it might be, and yet, you could still be liable as an employee, employer for that information.
So I would say, even if you're working in the cloud, there are things you can still do as an employer when you're transmitting that information to your payroll provider. Make sure that you're on secure servers and things like that. And you would tend to still be expected to do that part of it. The HIPAA thing does bring up cell phone usage and transmitting data through cell phones, and how safe is text message and all of these things. Generally speaking, the payroll providers that are out there, Paychex, the larger ones, not so much the newer ones, I would look into them further. Their systems are pretty secure, and they're going to be held to the same standard really as anybody else. If there's a breach in their system, they're required to let you know about that so that you can appropriately address it with your staff. And if you're uncomfortable because you're using a newer payroll provider and you're not sure about their policy, there's a lot of providers out there now and a lot of new ones. So I would call them and I would speak with their, their administrators and their people and ask them specifically what they're doing and document that discussion, because at least you can show later that you inquired, and maybe you can offset some liability by saying they represented that they were doing this in a certain way and then I found out in the alternative later. So that would be one way of protecting yourself in that area.
All right. Well, thank you. We are at 11:30. And so if anybody has any other questions or anything that they want to talk to Leanne offline about, go ahead and you can send us an email. You can still chat here. I think Sammy will leave the chat open for a little bit for those of you who want to send in a question via chat. And other than that, thanks for attending and happy post-Valentine's Day as well. And I think that's it. Thanks again, Leanne, for doing this for us.
Thank you. It was a pleasure.